Welcome to Legal Tip Tuesday. I'm Dick Galloway, and I want to talk to you a little bit about a products liability case. You've been injured at work. You were running a hoist, lifting a load. The hoist failed and dropped the load, crushing your left foot. And you come to us and say, can I sue my employer? And in Pennsylvania, the answer is no, you can't sue your employer. The exclusive remedy you have is workers' compensation. Can I sue the hoist company? Well, the answer is maybe. First, we need to know what happened. Is this an old hoist that simply wore out because the foundry where you worked had used it for 40 years? If so, probably you don't have a valid lawsuit. Remember now, you can't sue your employer simply because they were cheap and kept it around for 40 years, and we're looking at the hoist company. But let's say the hoist isn't 40 years old. It's 2 or 3 or 4 years old. And now we need to have somebody look at it who's an expert, probably a mechanical engineer. Pennsylvania law provides for liability for a manufacturer like this hoist company when a product is defective and unreasonably dangerous to the ultimate user. Here, you're the ultimate user, so you come within that. The product may be defective because of several different bases. One is the original design is defective. They put in too small a motor, or the brake was not sufficient, or it was improperly manufactured. They were in a hurry to get it together, and they didn't tie it together. They didn't bolt it together, fasten it the way they should have. Or they didn't give proper warnings. They should have told you that you should not stand under the load, etc. So at Quatrini Law, we review the facts. Was the hoist overloaded by you? If so, probably no claim. If the load was 600 pounds and the hoist was rated for 500 pounds, we're going nowhere. You've brought about your own injury. But let's say you were lifting 600 pounds and the hoist is rated for 1,000 pounds. Now we need to look at the specs on the hoist, hire an expert and examine the hoist. And let's say we find out that the gear teeth sheared off because of improper metallurgy. That is, they used the wrong metal, not strong enough for that kind of load, and that's what caused the problem. Now you have a valid products liability case, and we're probably going to be able to settle it or try it and get you a settlement that's well into the six-figure range. Now, you've paid nothing. We front the expenses for you, and we don't get a fee unless we obtain a recovery for you. And in this instance, in the meantime, our expert workers' comp lawyers are making sure you're getting your medical benefits and your wage loss that keeps you going while we're working on the lawsuit. And if it turns out that you're disabled, we also have people here who are expert at getting you Social Security or Veterans Administration benefits based on disability. All in all, we can cover all of these things and make sure that you're protected on the basis of the workers' comp injury, on the basis of disability, and most importantly for me, because I'm a trial lawyer, on the basis of the personal injury itself. We like to think at Quatrini Law we can cover all the bases for you and do a good job. This has been your Legal Tip Tuesday.